they must have, and I just didn't realize it had stopped working.
Do you know how long, probably?
Quite a while, because I actually had to stop my uploads to you guys for a long while, because we were doing our backwards. We were downloading so many documents so fast that it was really bogging down. Downloading and uploading.
First week, this morning when I was that actually is that
Really? Just recently? Because you did know once you fixed the free
I came home, I ran downstairs.
And what we downloaded all of the free color codes for a lot of
Oh, so you're going back and selecting all the...
Yeah. You've now downloaded, re-downloaded all the written opinion reports.
And you guys always pull a docket sheet too, right?
Yeah.
So you have all the case metadata.
Yeah.
Express.
Hey, yeah, as long as it comes out in some way we
I
understand.
think we have our uploads
Yes,
off
it
at
is.
the moment. You guys can read writer upload script.
Internet Archive has been having some problems.
Yeah,
Day and a half.
throwing up all over itself.
So yeah, a lot more documents to upload to you guys.
It's exciting.
Yeah, that's awesome. Yeah, we have another big repository.
Have you looked at that?
True. So
Yeah, I only went on the way out,
this is
and I way back in.
the repository that the IP litigation folks in Stanford when they were still at Stanford.
I guess you guys haven't worked with that at all.
It's a very focused work that's very focused on IP.
You have to be very cool to have to talk to.
And probably not as near broad interest as most of the stuff you guys have, but it's a good archive, and for, you know, even here, just the same way
Sorry, how's Sophie doing?
Really in the same person you.
You've only been the same regard as I
Can't
do.
say that.
Oh, I love Sophie,
We're
yeah.
looking into
Dan.
Yeah, I met you.
Yeah, we met.
Okay, sorry. It's like, I don't know your name, but I think I got one of the emails on the CC list. I'm like, are you?
Dan is your Stanford Supreme Court program.
Courtney, do you share that email or is it just my name?
share the annotation.
Yeah.
Yeah, they're really
Comfortably where you can't do that.
It'll just fall.
So like on any part of the website, you can add some text.
I'm just going to
Well,
ask you.
we're going off, like, there's so many places now that have case documents. They want, if you go, file on Cornell's site and annotate a Supreme Court case. And then
that's 10 times, yeah,
just the site by site.
We should talk more about it, but we should also probably start. All right, so I think we're going to get started. I'm Steve Schultz, and this is Harlan Yu. We're from the Center for Information Technology Policy at Princeton, and we're going to take a two-part approach today. We've been going around giving our recap and free pacer stump speech all over the place, and I'll do a sort of quick version of that. But then we're going to demo some stuff for you, both how the public system works and some stuff we're working on. Hopefully that will not even be the bulk of the workshop, and we can spend the rest talking about things that are of interest to you and the ways that our system or the lessons we've learned are relevant to you guys. So we'll rely a lot on you to help ask those questions and lead that discussion forward. But I'll start by giving a version of this, the general recap talk. And since we've got so much time to work with, I'm used to having to give this in like 10 minutes and then run off the stage. Since we've got so much time to work with, feel free to interrupt me and ask questions and that sort of thing.
So maybe before we start,
Yeah, go ahead.
it might be good for us to see, you know, who's heard of recap before and who's using recap. So that might give us, so who's heard of recap before? All right, so we can just go over. Who's using recap? Or cool.
All right, so I won't spend too much time on details.
Who hasn't already?
All right. Yeah, so that's what I already talked about. Oh, that's the same slide. All right. So usually when I talk about this, depending on the audience, we talk about sort of big picture why open access to case materials is important, why free and open access is important. I'm assuming I don't have to sell that idea to many of the folks in the room. I talk about why the Star Chamber was a bad idea and how we translated the principles of open access to courtrooms into the physical architecture of the courtrooms we built with big public galleries and that sort of thing. And then I showed this, which is one of my more favorite images. This was in the LA Times in '97, and this was their vision of what a courtroom of the future would be. And it's really cool. I want to go to this courtroom. This is the judge. He's like a digital being surrounded by laser discs. And he's shooting laser beams. There's a lightsabers or something. There's a robot bailiff here, VR goggles for members of the gallery or members of the jury, and touchscreen computer access to case materials. And we didn't get those. Oh, and the hovering cameras covering every aspect. And of course, we have some active camera in the courtroom debate that's gone on in the last couple of years. So we didn't get the cameras really. We didn't get the VR goggles, but we did get the computer access to case materials. And I guess if you're accessing it on your iPad or something, it could be touchscreen too. So the future is now. This is probably also a review for most of you, but Pacer is run. The infrastructure of Pacer follows the same infrastructure of the courts, quite literally. So within each district court, actually within each district and bankruptcy and circuit court, there is a separate server running local Pacer software, and there are network connections to all of these locations, and the courts are paying someone at each location to administer the system. And that has implications for costs down the road and some of our arguments about the fee structure. Yeah?
Why is there a red dot everywhere but Arizona?
Man, I think I also left out the Southern District of California. I apologize.
There should be 210 or something, right?
Yeah, well, I was trying to do district courts here, but I missed a couple.
98 districts.
And the plus bankruptcy. And the plus appellate.
And those your favorite mistakes?
Yeah. You guys are really detail oriented.
Big rule.
Steve just put random dots up on the map. You guys are
No, and I've given this talk many times.
I just always feel picked on. I'm just like.
Are you there? This presentation is not going well. You all know what Pacer is for the most part. It's run by the Administrative Office of the U.S. Courts, which is a sort of sub-administrative agency within the judiciary. It's kind of a weird beast if you compare it to the agencies we're used to talking about, executive agencies that have oversight under APA guidelines and that sort of thing. The administrative office is kind of weird because it's within the judiciary, and they're not supposed to be a policy-setting body. The judicial conference is supposed to set policy, and the administrative office is supposed to implement it. We have very little insight into what the AO and, to a large extent, what the judicial conference is doing around policy making on a day-to-day level. So some of the documents that I had to get in order to put some of the numbers together that you'll see today were a major pain to get because there's not the sort of traditional oversight that you would have in a normal agency context. So two issues with PACER that we typically talk about. The first being cost, which I think is probably a sensitive issue for a lot of folks in the room. You probably know that PACER charges you 8 cents per page. That's easier to understand in the context of PDFs, a little harder to understand in the context of search results. And you get charged for every page of search results, docket sheets and the like. And then on top of the fact that there's a fee for use, the broader public implications for public access, there are broader public implications to the fact that you have to sign up for an account before using it, and the system isn't indexed by Google in any particular way. Erica, I told you I'd probably call on you. Can you give a sort of overview of the results from your law librarian survey about their PACER use and how it affects their behavior?
Sure. Well, just in a nutshell, of the, I think there was something like 200 law library responses. We sent something out to Law Live and also said no cal, so not scientific in any way, but we got about 200, a little over 200 responses, and it was asking them if, it was very simple, I think it had 3 or 4 questions. Do you use PACER? Do you let your patrons use PACER? How much do you spend a year? Do you restrict in any way because of cost? And basically, I think the biggest nugget that came from it, obviously the firms spend a lot on PACER, and I think the highest reported entry, I think one firm in San Francisco said they spent $120,000 a year on PACER, dollars, US, and not pesos. Yeah, and then just, but you guys didn't reply. And the, but no, that's okay. Yeah, and then of the 66, I think there were 66 law schools that responded to the survey, law school librarians, and 63 of them said they restrict access because of cost. It's just too expensive. And we're one of those schools. We don't allow our students to have unlimited, unfettered access to PACER. It's just too expensive. We had one student once. It's all because of like the once you get bitten, we let a student actually sit near us, so that's what's even funnier. We just totally got taken. She sat next to us and said, I just have a few searches I want to do, and we checked the bill, and she spent $500 in one day. And she wasn't doing bad searches. I was looking at it. It wasn't like she was reloading the same thing 20 times. She was just doing normal research. She was trying to write a paper. She was in 3rd year, and so she was trying to. We can't afford that. You couldn't do that. That's just crazy.
Does that experience track with other folks who use PACER or instruct students to use PACER? Does that experience track with your experience or not? I'm just curious as a sort of anecdotal matter.
We don't let our students use it.
Yeah.
They have to come to us and tell us what they want, and we narrow it down for them or help them, and then we'll go on and we'll get the documents and then we'll give it to them. And normally it's like right on point. They're like, that's exactly what I was looking for. But we don't even say, oh yeah, here you go, Bob. They don't even know what it looks like.
Right. Okay. Interesting. Yeah.
We always log them on, like kind of like it's what you do, log them on, and then they can sit down and do what they need to do. But we have 2 bankruptcy classes, one of which the professor requires the students to use it, and he actually put it in part of their take-home exam. And so after a lengthy back and forth with both the Office of the Courts and the professor, my boss finally relented and got a separate account just for this class, and the bill goes right to the department. So each student was given the password in that class.
Interesting.
And then each term, we changed the password.
Fascinating. Okay, so it sounds, Erica, like, at least anecdotally in this room, the results of your survey are pretty representative. So related, in some ways related to the cost issues, but also more broadly related to usability is a series of issues with what you can do on PACER. And of course, when you can't search very well on PACER, you tend to incur more bills because you spend more time searching for what you're looking for. So no full text search is obviously a bummer, and it makes it
Understatement.
it makes it more difficult to find what you're looking for. No document authentication is an interesting one, and this has been a big issue that AALL has pushed and would be a huge boon to us as well. If these documents were digitally signed by the courts, then people who want to use those documents downstream or redistribute them can do so in such a way that their users are sure that they're getting the real thing. And this is a very concrete problem we run into with RECAP, as I'll describe in a couple slides. The other issues are there are no structured or very poorly structured documents, especially with respect to case metadata and the like. And Justia has had to struggle through the parsing of PACER pages just as much or even more than we have. And I've now heard like from 4 or 5 different parties who have all written their own parsers for PACER. Of course, because of the distributed nature of the system and the fact that local clerks are able to change things about their own PACER implementation, and the parsers tend to break all the time. And in addition, as the versions are upgraded, they change the way things are formatted, and they roll the updates to the PACER system out in completely unpredictable fashion across the whole country, so that we're, at any given time you're working with 8 or 9 different versions of the PACER system if you go to different jurisdictions. And then there's the user interface in general. So privacy concerns we sometimes talk about in more detail. I'm not sure how interesting this is to you guys. Of course, there are a lot of pieces of personal information that end up in court records. There are supposed to be rules of Federal Civil Procedure, Rule 5.2, which outline things that counsel has to properly redact. But as we have discovered, counsel often either doesn't know, makes a mistake, or somehow allows private information into the record. Sometimes they're not really motivated to watch out for private information because the private information in the records is not for their client, and it's not for the client of opposing counsel. It's for some third party who's named in the record. The one interesting thing, perhaps, for this group with respect to privacy is that it represents a big potential research area, looking into ways that we could better, in a more automated fashion, redact documents and protect personal information. Another graduate student at CITP has done some work in this area, using a machine learning technique to try to identify documents that have unredacted personal information. And I know there are vendors out there that sell similar commercial solutions. All right, so we're shifting a little bit into advocacy mode. So the E-Government Act of 2002 modified the enabling statute for the judiciary, which enabled the enabling statute enabled the judiciary to collect fees for PACER use and also to carry them over from year to year. It modified the enabling statute from saying that they must charge to pay for the system to they may charge only to the extent necessary. And in the accompanying Senate report, Congress made its intent clear by saying that it intends to encourage the judicial conference to move to a free system as much as possible. And we think this is a fairly clear statutory articulation of what the courts are and are not allowed to do. But the courts aren't complying with what our understanding of the statutory requirements are. And this has a direct effect on the fees that people pay. So this is the judiciary's financial plan for 2009, explaining what they're going to spend PACER fees on. So up here they say they're They're going to use $106 million worth of EPA collections, which is electronic public access collections, on the following services. Everything highlighted in red here is not clearly PACER. It's things like courtroom technology allotments. What's that? Well, that's putting flat screen TVs in courtrooms and things like that. Or like getting a robo-bailiff or something. So we think that this is a problem, and the fact that there's little oversight of the judiciary and the decisions and implementation of those decisions by the Judicial Conference and implementation by the Administrative Office compared to a normal agency makes it a challenging space. And of course, you don't want to try to challenge the independence of the judiciary. They exercise their own authority for a pretty good reason. But nevertheless, you want good public access to public records for all of the good democracy-enhancing reasons. So another view in on their finances, I have a longer blog post on this, which goes into detail and refers to the specific documents I pulled the numbers from. But to give you a sense, over time, this is obviously millions. This is how much the judiciary claims that PACER has cost them over time. You can see it rising slowly. The fact that it even costs $20 million, this is per year. $21 million is remarkable in and of itself. This is a carryover from year to year. So in 2008, they had, I think this is like $44 million worth of carryover, meaning they took in $44 million more than they had to spend. But you'll notice around the same time, they also decided to start spending more aggressively on non-EPA or non-PACER expenses, so they managed to spend that out. They plan to have it mostly spent out by the end of 2011. In fact, this year, they're planning on spending more than they're even taking in. This is income for a given year. They're planning on spending more than they're taking in for that year on non-PACER things. The reason they can spend more is because they're spending half the carry forward. There's some active discussion about whether or not these are truly non-electronic public access services. I'll step back real quickly. It's an interesting controversy, so let's well describe it. So case management and electronic case filing is the core electronic filing system for the courts that PACER relies on. So CMECF is used by attorneys. In fact, it's mandated in most jurisdictions now that attorneys file electronically and manage their case that way. PACER is a sort of public front end and billing system built onto CMECF. So what the courts try to do is say, well, PACER relies on CMECF. In fact, the systems, the underlying infrastructure is the same, so we should be able to pay for all of the expenses of the filing system using public access fees, even though there was no increase, no change in filing fees when attorneys went from filing in person to filing electronically, which means that essentially the courts are providing the new electronic filing system for free. And the filing fees that attorneys do pay for initiating new actions and that sort of thing don't go to pay for the system. They go to the general fund. So in any case, the courts are cross-subsidizing development of CMECF with PACER fees, which I think is unconnected. But more offensive are the things like courtroom technology, as I mentioned, the electronic bankruptcy noticing system, which tells creditors when debtors file for bankruptcy. They're spending $9.7 million a year on providing that service for free to creditors based on their PACER revenues. All right, so I gave a version of this general advocacy talk at Princeton a year and a half, 2 years ago now. And Harlan...
A year ago.
A year ago, oh man, a year and a half.
It was about February of last year.
Wow, a lot's happened. So I gave a talk at Princeton. Afterwards, Harlan and Tim, both grad students came up to me and said, hey, someone should build a Firefox plugin that automatically contributes all Pacer documents that you download to a public archive for free, and then lets you easily find those and download those instead of paying for them. So then that's what we built. So most people here are familiar with Recap already, but the basic outline for those of you who might not be familiar is when you download a Pacer document, you upload it, your browser will automatically upload it to the Internet Archive. You get a little pop-up that says, hey, I uploaded this to the archive, either the docket or PDFs. When we send it to the archive, we convert it into a much more machine-readable format. So we go from the messy HTML into a standard XML format that we defined and have a XML schema for, so that people who want to use those documents down the road can much more easily parse them out and identify the relevant things. And we might show you a couple of those documents. And then the other half of what Pacer does, or what Recap does, is when you're viewing a Pacer docket, normally you just see 1, 2, 3, 4. If we have a document already for free, we put a little R icon, and if you click on it, it lets you download it for free instead of paying for it. I should update our status report. Oh yeah, this is an even older document. I have a newer version of the slide. So we have 2.something million.
2.2 million.
2.2 million documents now. We worked closely with Carla Malamud from publicresource.org, who had a big repository, which we slurped in to help feed our database when we got started. Justia has been automatically uploading everything that they download to our system. And we're looking at other folks who have existing big repositories that we can kind of use to bootstrap our system. But we've now gotten probably hundreds of thousands of documents from users that are using Recap. It's interesting. So the courts claim that in the Pacer system overall, there are about 500 million documents, which is believable. And so we have 2.2 million or so, which is a pretty small fraction of those. However, we tend to have the most interesting and relevant ones because what we download is directly tied to what people are interested in and go to. So I have now, on many occasions, heard about a case that was going on. I was interested in it. I wanted to look at the case materials. I looked it up on Pacer, and somebody had already downloaded the documents for me. So I think we're doing a decent job of getting a lot of the high-value documents for free already. Yeah, we got a bunch of people saying nice things. We had a little bit of back and forth with the indirect back and forth with the administrative office after we launched this. We didn't know if they were going to sue us or sick the FBI on us, which they'd done to one other guy. And they released some slightly scary language at first, which they encouraged all of the courts themselves to post on their Pacer sites, talking both about how Recap is open source and that's frightening, and talking about how people who had obtained fee waivers for Pacer use, which is something we should talk about. Talking about how they are not allowed to use Recap because the terms of getting a fee waiver don't let you redistribute documents. So there was a period there where we were not sure what the court's response was going to be, but slowly they seemed to come around and demonstrate that they were, if not happy with what we were doing, they couldn't figure out how it would be illegal or practically how to stop us. So on the advocacy side, you know what, Harlan, I'm going to let you do this part because you're best at this part, and
right, so
you wrote a lot of this.
So essentially what we want to do is we want to wean the AO and the federal courts off of Pacer. But I think there's a practical problem of how we find the money to pay for all of their technology projects, which we think are good, but we think that those projects shouldn't be paid for and come at the expense of public access to the law. And so one of the tough things about getting to the recap documents right now is that in order to get the documents, you still need to have a Pacer account, right? You still need to log into Pacer, put your credit card in, get an account, and then do the search, which is hard to do, which will cost money. Get the docket sheet, which again costs money, and only then will you be able to easily find which documents are in the recap repository. So we made some recommendations for what the AO could do to immediately start providing much better access to these documents. And so we suggested that they make all the Pacer searches for free, which would allow people to find the cases easier. The docket sheets and the opinions are technically free of charge. There's been some issue with some courts not marking the opinions correctly, and so some of them are free, most of them are free, some of them are not. And so our recommendation is to make those things free and also to decrease their 8 cents per page charge to what it actually costs to provide Pacer, which, looking at all the court budget documents, they're charging users about 4 times as much as they should be. So something about 2 cents per page might be more reasonable. But even then, given the way that the Pacer infrastructure is built, there are lots of efficiencies and a lot of savings they can get. So, if they didn't charge money for the documents at all, they could basically stop. They could kill the whole billing infrastructure, which costs them multi-million dollars a year to send out bills and notices and go after people who have Pacer debts. So the second immediate goal as well, which is another really big hurdle, I think, into making this whole corpus of documents available, is the privacy problem. So in the whole back file of court documents, as Steve was alluding to earlier, there's tons and tons of private information. So Carl Malamud did a privacy audit last year and found tons of social security numbers, names of minor children, addresses, bank account numbers, things like that. And so even though we have all of these documents to sort of put them all up on Google and somebody searches their name and suddenly finds their social security number, that's probably not the right thing to do. Ever since we released Recap, and whether or not this was related to our release, I think they realized that eventually all of these documents will become public. So they sort of tightened their privacy rules and forced people to actually check a box on the CMECF side, the court management filing side, to basically attest that they redacted their document before making it public. The third thing that would be really helpful for us and for Justia and for other third-party providers of these court documents is to digitally sign using cryptographic digital signatures that basically prove that allows us to prove to other people that this PDF that we have, which is a decision, actually came from the courts. It's actually sourced at the courts, and it wasn't modified in transit. That's what a cryptographic digital signature will get you. So by having them sign it, we can be sure that these documents are real. So one of the problems for practitioners who want to use recap documents is that they're not exactly sure that these are real documents. They didn't come from a secure site, right? Somebody could maliciously, write their own opinion, tag it with the right metadata, and upload it to the recap system, and we have no idea whether or not that document is real or fake. And so by digitally signing all the documents, that would really help in terms of what we do. Medium term, it would also help if they started providing the court docket sheets in standard machine parsable formats. One of the big issues, again, that Steve alluded to, is that the administrative office, they develop the Pacer software, and they ship it out to the 200 district and bankruptcy courts. But each local court can make their own modifications. So, some Pacer pages have a teal background, some of them have a blue background, some of them have a brown background, right? These are all local modifications. But not only do they modify the background color to, make it their own personal customized site, sometimes they tweak little portions of the docket sheet, sometimes it's capitalized, sometimes it's lowercase, there's no colon, they do a whole bunch of things. But that makes our job hard because when we need to write computer code to automatically parse out the constituent parts, we might need to make small modifications for each court depending on how they modified it, so to compensate for those. So if they provided the dockets in some standard format, like we eventually convert the dockets to, that would make our jobs much easier too. Another issue is, when new documents go into, as a court case is going on, and there are new documents being put online, it'd be great if they can notify us and Justia that those documents are there so we can go grab them and go buy them. And then, as we were talking earlier about the budget, the E-Government Act of 2002 states that the courts are able to charge fees. And so if we want them to take down the paywall, they need money from somewhere else, practically speaking, to pay for this system, right? The money's not just going to come out of thin air. So we would like them to formally ask for appropriations through Congress. And there are other interesting ways that we can also discuss strategies for making up, not just the $21 million that it costs to run the PACER system, but also find money for the money that they're currently using to buy courtroom technologies. And so some of that might be reappropriating money. So again, Carl Malamud, he filed a FOIA request to all the executive agencies last year. And he found shockingly that DOJ itself is paying the courts $4 million a year to use PACER. So that's, they're probably the biggest user of PACER. And these are this is taxpayer money going to DOJ, and then DOJ every year is paying the courts. So, it might cost $21 million to run the system, but instead of paying DOJ to pay the courts, we might as well give that money straight to the courts and then add up all the other agencies that are, basically funneling money to the courts. We might be able to just directly reappropriate and get them to take it down. There are other things about court filing fees. So maybe we can just bump up the court filing fees just a little bit for, not nonprofit and, not pro se litigants. That might, make up a little bit of the offset. But ultimately, our goal is to put ourselves out of business. So we run this recap system, we run this repository. We don't want to be running this repository, right? We want to put ourselves out of business. We want the courts, to put this information out themselves, right? In machine parsable ways with authenticated documents, so everyone can have access, to what is really the law of the land. So that's recap.
Yeah, that's the end of the stump speech. So we were thinking it might be useful to show you, do a demo of how the system works, show you a little bit of the internals, because that gets to how we store information and how, if you were doing research or if you were designing larger either analysis systems or your own systems for archiving legal materials, maybe some of the lessons we've learned can help. And also give you a sneak preview of a web front end that we're working on so that you could search the recap archive directly. But before we jump into that, does anybody have any questions so far, or feelings like we should be talking about some other aspect that would be more useful? No? Oh yeah.
One of the reasons why I haven't downloaded the recap yet is because I'm concerned that it could damage the court's ability to make those documents available.
Yep.
And I'm wondering if you thought about it.
Yeah, absolutely. What we're doing is a challenge to essentially the business model of PACER. I think it's unlikely that recap would directly have a substantial effect on their bottom line, although it's hard to know. If we get more and more users, maybe it would be a substantial effect. But our position is that the courts need to confront the fact that they don't have a fundamental right to arbitrarily charge for the documents. And so, yeah, it's a challenge to them directly. I think, as a practical matter, as I said, I think it's unlikely to have such a substantial effect that they would have to shut down the system or something. And I can't even imagine the public outcry if something like that happened. But yes, it is a direct challenge where we're taking money that would otherwise go to them and we're not giving it to them. Of course, if they're running these huge surpluses, it doesn't seem like they're currently in danger of being even close to the bone on funding PACER.
Right. I think if they were close to running out of money or getting bankrupt and not being able to run the PACER system, you wouldn't see these non-EPA spending the way that it is. They would hold on to their carry forward to keep the system alive for more and more years. But in fact, they're actually aggressively spending it on literally embedded speakers in the back of the benches so people can hear in the back of the courtroom and other things. So I don't think there's actually a worry that recap will actually make a dent into their bottom line at all.
But I respect it as a principal position, and I could see taking that position. I don't know if other people have thoughts on that. It's certainly the argument that when we say the court should stop charging for PACER, their answer is the system wouldn't exist unless we charged for it. And I think what you're saying is a variation on that. And I can respect that position. As a practical matter, both sort of in terms of budget, bottom line, and politically, I don't think it would ever shut down the system, especially not because of us. But our hope is that it can start to assert some pressure on them. I don't know. Does anybody else have thoughts on that? No? All right. So we thought I'll just show it in action.
Are you going to mention the fee waiver bit?
Oh, yes. So we're going to talk about fee waiver. So there is a fee waiver system by which individuals can petition for a fee waiver from a particular court. And you have to do it district by district. There's no such thing as a national PACER fee waiver. So you can do this, and when you petition for a waiver, you have to state the reason that you're asking for it, either in the form of, I'm interested in this particular case, or I'm interested in this relatively narrow research question. And you have to essentially agree that you will use your fee waiver only for that purpose. So it's not as though you can get a fee waiver for an entire district or for a bunch of districts and just download everything that you want. They might get upset with you and say that you're breaking the terms of your fee waiver if you did something like that. Erica, you've worked with people who have gotten fee waivers, at least in the Northern District of California, right?
All over, actually.
Okay.
There are a few professors who have done it.
Okay.
And it's time consuming.
Yeah.
Because it's they don't have a form, and it's just click here to get a fee waiver, which
Right.
would be wonderful. I mean, you actually have to write, just like an order to the court or a request for action. And,
Right.
What were you going to say? Sorry, I didn't know what the question. Oh,
I was just going to ask you about your experience with doing that. I know you had worked with people who would.
it's painful, and the thing that's, well, I guess I can say this off the record. I was telling you about this. It's kind of interesting how they are very aware of money, because recently one of our folks, this cannot get tweeted, one of our folks who got a fee waiver to a large number of courts got a call from the service center in San Antonio from PACER saying your fee waiver access will be discontinued, disabled immediately because someone else at your university hasn't paid their bill.
Right.
And then I had this horrible customer service conversation with that customer service person saying, how is this possible? I said, well, we look at the billing address, and even though they're not paying the fee waiver person, the ultimate bill goes to the same place. So we figure if we tell this person they can't use it, you'll get that bill paid. And that's what happened. We got that bill paid. But it was someone who isn't even, a faculty member at our school. It was someone with the same, zip code, and that's it.
Right.
It's crazy. I asked, what about students? Because you can't trust a student, and he said they would draw the line at a student, but kind of strange.
Right. So it's good to know that that the fee waiver option is there, painful as it is. Sometimes if someone's trying to do research that requires downloading a large number of documents, it's worth the upfront cost of getting the fee waiver. It's obviously it's a flawed system, but has some utility, and hopefully it'll be irrelevant in the future. The other thing I would say, I don't know why this reminded me of this, but the other thing I would say about people approach us wanting to do research on the recap corpus as a whole, often academics. We're totally open to this. The only concern we have about it at all is related to the privacy concerns that we outlined. What we wouldn't want to do is sort of facilitate large-scale, easy identity theft or something.
I mean, it might be good to add here, too, that when we get PDF documents that come into our system, when the PDF itself has a text layer, we actually scan the text layer for a regular expression that represents a social security number. And we have those, we'll suppress them. But oftentimes, they're scanned documents, and they're not natively imposed on the computer. And so we don't actually have OCR software that we're using to OCR the documents and also do that scan.
So we have some mechanisms where we're cleaning a lot of this private information out, but there's undoubtedly some in there that we're not catching.
And this is also only Social Security. There's other kinds of private information that is just really hard to automatically detect. A child's name, pretty difficult.
So at the moment, we don't just post a big zip file of the whole recap corpus for easy downloading, and we actually block automatic Google indexing of the text of the documents that we upload, although we do allow Google indexing of some pages that include the basic case metadata. So if you're searching on Google for a particular case, you can get a hit to an Internet Archive page where you can get all the materials. You can't currently do a Google search over the full text of what's in those PDFs because that's blocked for the privacy reasons we've identified. And we see that as a temporary measure that we ultimately want to remove because it takes away from the utility of the system. But all that being said, the recap corpus could certainly be useful for certain types of inquiries and certain types of research. As I mentioned earlier, it's obviously not a representative sample across all of the courts. It's stuff that we got from our bulk partners or the documents that users have uploaded that they're interested in. So if your research requires some kind of representative sample, that might be harder to do with the recap corpus. But if anyone is interested in getting access to the corpus as a whole or on an individual basis, we're happy to talk about it. All right, so we described the system in general on our Recap the Law site, which is where you can download and install the plugin. To show you the system in action, actually I'm going to log out just. But I have a great animated graphic on the picture. All right, so when you have Recap installed and you log in, it'll tell you it's activated. You get a little R icon that turns blue in the corner, otherwise it's gray. And it'll be blue anytime you're logged in and on one of the Pacer sites. And I already have a search up here. So I had. Oh yeah. All right. So this is one of my favorite cases to use as an example. It's one of the Obama birther cases. Oh, I guess it was close. All right. So anytime you look at a docket report for a particular case, actually this is a not yet released feature, which will actually look better in the release version. But we actually, when you're about to do the docket report, we now give you a link to the recap, the free recap version of the docket. So you no longer have to pay. If you want to look at the free recap version, you no longer have to pay to look at the for-pay Pacer docket. And this text is all not final, but we'll have some disclaimer saying basically you can grab this docket. This is the last one that we saw, but there might have been new updates since the last time someone downloaded it.
Right, and the reason why it could be potentially incomplete is because we only get the portion of the dockets that people pay for. So if you fill out this form and you say you want documents number 1 through 20, right? You get the docket sheet that has document 1 through 20, but if there's 20 through 50, we don't get those. And so what we do is we basically merge dockets together as people buy them. So if somebody buys 1 through 20 and somebody else buys 20 and 30, then we have 1 through 30, but we wouldn't have 30 and 50. So the docket sheet that's available from us may or may not be the complete docket sheet for the case, which is why there needs to be
I have that little disclaimer.
that disclaimer.
Now, when I view this kit, this one happens to have all of it. I didn't download these, so someone must have. I don't know who downloaded all these documents. A lot of them are recent too. In the docket sheet, I can either pay for a document by clicking on the number, or I can click on the recap thing to get it for free. It says it's available. Oh, and there's also an attached exhibit or something. So it says you can download that document as well if you want to. Well, I guess I'll show you it actually downloading. It's just downloading.
So this document's coming from the Internet Archive.
Right.
Which is a private nonprofit run out of San Francisco.
Right. And one nice thing that we do in Recap is by default, we'll always check the button that gives you a document with the actual descriptive metadata at the top so that you can track your documents. And that's really it for the what Recap does demo. I should show
the Internet Archive.
Yeah, I should also show uploading a document from it. Should see download.
They downloaded the
25.
attachments, but they didn't download the
29.
Oh yeah, they download the attachment. You're right. Right. So if we download the main document, they court 64 cents right now. It'll give us the document. One nice thing that we do, it says it just uploaded the PDF to the archive in the background, as you know. One other nice thing we do for you is a lot of times you get weird garbage file names out of Pacer. We give you a nice one that says this is from the U.S. courts, DC district, and then this is an interesting part of it. So this is a unique number for this case, document number 25, attachment number 0, because it's the main document. And I don't know if people are interested in this, but I'll give a basic description, and if we want to talk about it more, we can do that. So this is a unique identifier for the PDF. In a sense, it's a citation. It's not a citation that really anyone else knows how to use, because we're using a unique identifier for the case here, which is an internal Pacer system unique identifier. And I think this will come out if any of you go to the law.gov session, which is next. It's an interesting question when you move into the digital domain, trying to translate the existing notion of unique citations and a lot of the work that's already been done around uniform vendor-neutral citations, and translate that into the digital space so that we can all know what documents refer to what. And this is they'll probably talk about it in the next section, the digital URI, or Uniform Resource Indicator question. And there's a lot of work in that space, figuring out, well, what in order to keep track of which documents are related in which cases, et cetera, how do we define that? And as a practical matter, we settled on using this internal Pacer unique identifier for each case, because we knew that it would be unique, and we would always know how to link back to the case in question. It's not great for human readable purposes, but we actually have a feature where you can change it from what we call Internet Archive style to lawyer style. And if we go back and download the same document, pay the courts another 64 cents, we'll have something that looks a little bit more like a Blue Book style citation. So a DC District Court, the docket number, and then the document number 25. So anyway, that's a useful sort of minor feature. But those,
Sorry, you upload it twice in 2 different file names?
No, the file name that we use on our end is the first style I showed you. All we do is, as it's coming to your browser, we give it whatever file name you want. But in the back end, we're using the first style for everything. All right. So the other thing I'll show you very briefly is this is what this is on the Internet Archive. It's not very pretty. It's the basic information, but this is the version of the docket that we have on the Internet Archive. In fact, what we put on the Internet Archive is standard XML format, and this is a simple transformation into HTML of that XML format. But what you can see is we have the same basic information that came off the docket sheet. I thought of this just because I was going to make the point that the links on the Internet Archive, you guys can see this, the file name is that first style file name. The other thing I'll mention, just in terms of a useful, recap being a useful tool for you when you're doing case research, is this URL for this document is a permanent URL which you could post on your blog or pass around. It's publicly accessible. It's something that you can easily link to. It's the same link that you would get if you were looking at the docket sheet from within Pacer, and you saw the our icons here. I moused over, I didn't see it's the same URL. So sometimes if I want to blog about a case, I'll download it on Pacer with recap enabled, grab the URL so that I can then link to the argument or whatever that I wanted to talk about. All right, and then the final thing we wanted to show you was a preview of a web-based browsing system separate from the Internet Archive. There's some very limited functionality on the Internet Archive you can already use to browse through the system, but the basic way that most people access recap archive materials is by using Pacer and having the recap plugin installed. But we've been working on this web front end to the archive, which will be releasing hopefully in a matter of a couple of months or so. There are some user interface changes and the like that we want to make, but I thought it would be worthwhile to show you very briefly what it looks like and some of the functionality, get your feedback on if there's anything else you think we should be doing. So first and foremost, here, I'll just go back to the page. You can do full text search to find what you're looking for. So Orly Tates is one of the attorneys in these birther cases. So if I wanted to see all the cases that she was working on, I might search for Orly Tates. I get a few search results here of case names. One of the user interface types of things that I want to change before this goes live is to actually give you a little bit more context about what court this came from and that sort of thing. And if you have thoughts on that, let me know. But Rhodes versus McDonald et al. Was the case that we were looking at on Pacer. This is the version of it on our web front end, which is feeding off of the Internet Archive database. We've actually built it in such a way that we first write, through the extension, we write everything in the Internet Archive, create these XML files, and then we built our system as though we were some third party coming in to build an external system. The only inputs into our system are the information that's on the Internet Archive itself. So if somebody else wanted to do this, they could do it as well. So in any case, you can look through the case, the Pacer case numbers, that unique identifier we use that I mentioned. if we wanted to look at the complaint that we had just downloaded from Pacer, we can download that from here. It's again pulling it from the Internet Archive, and it's using that same format. Was anything else?
We'll buy from Pacer.
Yeah, so if we don't have it already, it gives you a buy from Pacer link, and that just bounces you over to the right URL on the Pacer site where you can buy it. If you have Recap installed, it will then, of course, re-upload it into our system, and when you come back to this page later, it'll say download instead of buy from Pacer. And if there are parts of the docket that we may not have coverage of, we say documents in this range may be missing. It always ends with documents in this range may be missing because there could always be more things appended to the docket in the future that we didn't know about ahead of time. There's other fun stuff that that we'll include, and we're looking for more ideas about those types of features, things like being able to tag cases and that sort of thing, being able to subscribe to updates so that every time a Recap user uploads an updated docket or a new document for a particular case, you get an email notification or something in your RSS reader. Yes. Anything else you wanted to mention on here, Harlan?
Nope. It's 2:02. Does anyone have any questions about?
Yeah, it's 2:02.
Questions,
we
comments?
should probably let people go. If you want or need to go ahead and go. Otherwise, you can ask questions and we'll stick around.
I'm wondering if you guys have been planning on plugins for other browsers.
Yeah, so the biggest win would probably be Internet Explorer first, because so many people use or have used Internet Explorer. We looked into it, and it's very challenging, and we don't know how to code it, so it would also be expensive. So Internet Explorer probably. We looked into Chrome. There are some updates to the Chrome API that need to happen before we implement that. Yeah, they don't have an extensive. They don't really have a way for extensions to do anything with the download process. And we need to do stuff like download.
If they don't already have this much, when you buy a Pacer document, then for the person, if they don't have it installed, you should try to install it. Why don't you do it?
Splash page.
Splash page, I'll tell you, hey, by the way, you can support Recap, et cetera, by downloading this plugin. When you buy a Pacer document, from this side,
From this side. I think that's fine.
That's better.
So if somebody's just using it to browse.
Exactly.
We didn't want to make it annoying, right? If somebody doesn't want, if somebody wants to get these documents, but for some, let's say they're an attorney and they don't want to upload their clients'
Exactly, right.
documents, we don't want to.
You could at least ask them all these things.
Right, yeah, so I think we're planning on doing this.
I do also want to understand the documents.
Just like one free.
Exactly.
If people really want to.
You don't play that, it's totally fun.
So I just wanted to any cases of documents.
Oh, yeah, that's pretty easy. I mean, the free,
I know how to do it. Right. I wasn't sure if I was going to do it.
But others are just more like a letter.
It asked for privacy.
So what's the issue you guys would like to do?
I want to add, we have our whole document. I want to basically have it also be front end.
yes,
I want to go ahead and
that would be great.
So what you would need is basically,
all I really have to do is.
you need to know what's changed.
I'm not sure.
Yeah, you're totally welcome. Okay. You're totally welcome. And I don't think we need it.
I'm pretty sure I can do it. The only thing is
So we should get
that,
this recap.
one thing that doesn't really have on that, you've got your own
In case of RA,
follow the process. You don't write anything that's like global or
So you're USC.
of anything that's. Is
So
that right?
We can make one.
Yeah, we can make one. We, to build,
That would be helpful.
yeah, to build our front end, we actually